Where am I going to be? I think it's from like more one that you know more relevant and not more about it. Grenade so like but yeah. Well, she did. I did about people. You can't have running.
Hi, thank you for coming.
I know. Right, and then you do.
No, yeah, respond.
Yes. No, that's fine. Oh, okay. I saw your post, and they're out. So whatever. Yeah. What I wanted to but I wanted that. Yeah.
Okay. Yeah.
Really awesome day. Really felt something like where it was. It's even not, yeah, don't have a short of sleep. Oh, it doesn't have sleep.
Oh, Gary.
This stuff is everywhere. It was all of these I'm not playing all this. I'm doing you know when you I have a section that there's like this special. Oh, no, yeah, I'll sit down there.
Oh, fine.
What would you say? Like, speaking even for the shades that are on the couch? Yeah, they do. Yeah. So I wrote to them, but great. Protein company and.
Gary, back to you. No, we're all. The boss made that.
And then put us in the page of the CA. Okay. This is all right now. Yeah. Once I figure out how to make color and how to judge the I mean, they just feel out. Right. Yeah. Yeah. So, and it was just like, yeah. All I wanted to do was say to somebody about maybe fluctuated, wasn't the yeah, so don't let it stop. And that's what. But that'll be. Here.
Hey, Steph, how are you?
It's Popeyes, we have another fast food.
No, not another, same one.
No, but it's not there yet.
Correct.
All I'm saying is this town needs to thrive on shit.
Well, and economics. And when fresh and sweet proposes an application.
There's gonna be no more places left. Yeah.
I guess. Yeah. Thank you. Yeah. So you have. Yeah. Oh, no, that's right. Well, now, I know.
How are you? I don't hear. Right. Hoping to stay going back.
Yeah, and then everybody has their own.
Good. Going out of state.
Let's say in California, the ground right now. Wow.
You or
Me, it's gonna be Washington State. West Virginia.
That's you. That's what. Everybody. That's just.
Thank you. I didn't know it was like that. Yeah, she was, get out of here.
You can all send for her.
No, it would have been another thing. I think that would. I know. We're good.
Folks, and welcome to the planning board of Wednesday, July 23rd. At this time, I'm going to ask you to either silence your cell phones or turn them off. It will be appreciated. And we'll open up the meeting. Pursuant to the Open Public Meetings Act, this is to state for the record that adequate notice of this meeting has been provided to the public by publication in Union County Hawk on January 2nd, 2025, and posting on the borough website, and by posting and filing of said notice in the office of the municipal clerk. This is a regular scheduled meeting of the board. At this time, I'm going to ask for a moment of silence and a flag salute, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Adele, roll call, please.
Mayor Blumenstock.
Here.
Ms. Lysack. Here. Councilman Carney.
Here.
Chair Greet.
Here.
Ms. Bellagio.
Here.
Mr. Neersted.
Here.
Mr. Barkin is excused. Ms. Hay.
Here.
Ms. Bianco.
Here.
And Mr. Byers is excused.
Okay, and if everyone's had an opportunity to read the minutes of the May 28th meeting, do I hear a motion to accept those minutes as is?
I'll make that motion
Second.
to accept it.
All those in favor?
Uh,
Opposed? Hearing none, motion carries. Okay, we have several applications tonight. The first one being case PB 25-04, and that's for 54 Third Avenue. And that's a request for a certificate of nonconformity for a 36-unit garden apartment in the RA zone. And at this time, I'd ask for the representative to come up and let us have your name and.
Sure. Good evening, Mr. Chairman, members of the board. My name is Mark Liebman. I'm an attorney with CSG Law. I have a witness, Catherine Gregory, my professional planner. She is on her way. She's not here yet. I'm happy to present my case without her, but I prefer to have her.
That's fine, because I also am missing my legal representative, Don Frazier. So that's appropriate.
Okay.
Thank you.
Good to see you. Thank you.
Okay, great. Okay, well, in that case, let's move on, although I'd like to have Don here for that as well. Let's move on to Garwood Chicken LLC. Do we have a representative from Garwood Chicken LLC?
I think that was just a letter request.
That's it?
I don't think
Okay,
they were going to.
Oh,
no problem. Welcome to the board.
Are we up to the final?
Not yet, not yet.
my witness is just.
Okay, great. Then if you'd like to proceed, then go forward, and then we'll carry on later on. The very first one, 54 Third Avenue. That's the garden apartments.
Good evening, council, members of the board. Again, for the record, my name is Mark Liebman, CSG Law on behalf of Garwood Gardens, the contract purchaser of the property, 54th Third. This is, we have made a submission. We were here a few months ago asking for a rezoning. Yep.
Just adjust it for your level.
Okay. Is that okay?
Yeah, that's fine.
Okay. So I don't know if you want us to go through everything that we went through last time. I think it's all the same board members. We have the same reports, the same property. It's been there 85 years. The tax records show 1940, 1938. This garden apartment complex has been here. We have done Oprahs to the town, to the county to try and get some background information. We're told there's nothing available. It seems quite obvious that it predates the zoning ordinance, and we're here to ask for a certificate of pre-existing nonconformity for that property.
Okay.
Ms. Gregory's here to answer any questions, provide further testimony. We have been digging into this more since we were here last to see if we can find anything. We have found a couple little things, like I got the appraisal report from when the current owner bought it in 2012 that had a tax record that confirmed what the tax records now show. So I don't think that's really new. The tax record card is in our package. When the reval was done, I think about 6 or 7 years ago, it said that the building was 79 years old. That matches up with what we have. So I think everything's pretty consistent. This has been here for almost 100 years. So we think it's a pre-existing non-conforming structure.
Okay. All right. Thank you. If you'd like, you bring your witness forward.
Do you solemnly swear or affirm that the testimony you're about to give before the board will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, please state your name, give your address.
Catherine Gregory, 96 Linwood Plaza, number 350 in Fort Lee, New Jersey. I'm a licensed planner in the state of New Jersey.
Okay, and your licenses are all current?
Yes.
All right, Mr. Chairman, I recommend that we accept Ms. Gregory as a expert in the field of professional planning. And then I would suggest, Mr. Chairman, because we do have a comprehensive report in front of us, and we have already heard this, that perhaps the most efficient way to proceed would be if anybody has any questions that they want to ask about this.
I would think that's an appropriate way to proceed. With that, and yes, we accept you as your expert witness. So with that, I'll open it up to the board for any questions that maybe that someone has of this witness or of this application. Bill.
Does that include questions for Don? Wait,
Go for it.
go for it. Don, I just, it's,
Yeah, the applicant knows, they have no,
That's not a question, Bill.
how is a board member to respond when he has no exhibits, no testimony, no nothing, okay, to indicate that something is indeed pre-existing non-conforming?
The answer to that question is whether or not you believe that the applicant has established a sufficient evidentiary basis for the contention that it predates the zoning ordinance. If you want the applicant to have the witness move forward, that's perfectly fine.
No, the applicant has already submitted everything. I've read everything and
That's
they
what
were
I'm
here
saying.
last time. So there's no reason to go through that. I'm just, usually there's something,
It seems to me, Bill, here's what you can see here. You see the structure.
Mm-hmm.
It's pretty clear that structure wasn't built yesterday. The question is whether or not you're prepared to accept that that structure, from what you can see and what's there, is old enough that it clearly predates the zoning ordinance. If you do not believe that there's a sufficient basis to draw that conclusion, I guess you could deny this.
So could I make a suggestion? Mr. Frazier, if the applicant were to move this comprehensive report into, as an exhibit
It is.
with.
It is as part of the application, but if you'd like to have it marked with this evening's date by Adele, she can do that and we'll accept it as A1 in evidence.
I'm just thinking it would satisfy Mr. Neerstadt's concern without.
I don't
the
think
need
so.
to- I tried.
Hope springs eternal, but I don't think Bill's question is that this has not been moved into evidence. Bill's question, as I understand it, relates to, has the applicant provided quote unquote evidence that the existence of this garden apartment complex predates the RA single family zone? Whether we say that this report was already in evidence because it was part of the application, or we move it into evidence now, I don't think is a game changer here. Whether we have, I recall her name is Catherine, but I changed pages, so I don't remember your last name. I'm sorry. But whether we have the expert regurgitate a portion of what's in this report, I don't think is going to be a game changer now. I think it comes down to, do you think there's enough there that the applicant has demonstrated to your satisfaction that this thing was there long enough that it predates the zone? I don't know what else to say.
Chair, if I could,
Yeah, go ahead, Jen.
I am much more comfortable with this scenario, the certificate of nonconformity, as opposed to the rezoning, which is what was here last time. So,
I think Bill brought that up the last time.
yes.
Mistaken.
This is more, I feel more appropriate, and I personally can accept that this building was, at least appears to have been built before the ordinance, and I do accept that they have put in the work to try and find any other possible piece of evidence and have not been able to find anything that disagrees with that. I want to say I have a question, I guess, for Don on behalf of the residents, because I think what, the understanding of a certificate of nonconformity, it's, even to a layperson like myself, what does this mean in terms of what the owner is allowed to do? I think the concern would be not knowing what the owner could come in and maybe they want to build more. This does not allow for that, does it?
No, it does not.
Okay, so I want to put that out there for the public who
me
might
answer
be
your question.
concerned.
Your direct response to your question is, it allows what is there to remain. It
Thank
does
you.
not allow for expansion.
If at any point the new owner would want to expand, they would have to then come back before the planning board and we would be able to approve or disapprove of that. Would that be the process?
They would need, in my opinion, a use variance, which I know you know and the members of the board know, but for members of the public's edification, is a heightened level of scrutiny and proofs that the applicant would need to submit to try to expand this. And I think it's fair to say that it would be, on facts that I know, extraordinarily unlikely that any applicant would be able to receive such use variance approval to expand something like this that is already so far non-conforming to what is permitted in the zone.
You're still very careful. I love how you put it. Thank you. I simply wanted it out into public, report that is the case. If we do go ahead and this planning board does approve the certificate of nonconformity for the relief of the public to know that that does not mean that further construction in terms of number of apartments is happening. It will
Absolutely
simply-
does not mean that.
Yes, So I think that would be the main concern on the public. Since that is not the case, I am comfortable myself voting in favor of the certificate.
I would like to have like a 5-minute overview of what's in this packet from your professional, even though I think it would be better if all of us heard it, especially the people out, sitting here, like in the audience, just a couple minutes.
Sure.
That's all I
The
meant.
eyes and put on your witness.
And just,
Like you brought a witness here. Let her just, do an overview, please.
and I just have
Thank you.
one more clarification that I'd like Don, just to clarify.
Witness here.
I know that. But just again for the public record, if this were to be sold by the applicant right now, it would revert back at that time, even after approval by this board for that variance.
No,
No.
first of all, it's
No.
not a variance.
Okay, let's clarify that
It's
then.
not a variance. This is being done in lieu of a variance,
Okay,
okay? All this board is doing or is being asked to do is to recognize the factual question of does this non-conforming use predate the zoning?
Mhm.
ordinance? If in fact the board is persuaded that in fact this use does predate that zoning ordinance, that just means it's allowed to stay.
Mhm.
And whether, well, this is, I guess, a corporation here, but like, let's say it was a person
Mhm.
and they died, it was a two-family, could their kids still use it? Yes. Could
Mhm.
their wife still use it? Yes. If they sold the two-family in a one-family zone, can the buyer still use it as a two-family? Yes. All those same things and examples would apply here. If in fact the board is persuaded that this use validly predates the zoning ordinance, that means they're allowed to keep it that way.
Mhm.
And if they were to sell it, the buyer's allowed to keep it that way. In fact, as a very practical matter, but for the fact that someday somebody might want to sell it, or someday somebody might want to take a mortgage or something against it,
Mhm.
probably nobody ever comes in on this application. The reason you do an application like this largely is to make sure that you have the ability to sell it or mortgage it or do something with it. Because nobody was going out and giving them summonses saying cease and desist from running this apartment complex.
Mhm. Okay, thank you.
And just to clarify, the applicant is the contract purchaser for it, and that's exactly the situation that we have here, Mr. Chairman. My client is buying the property, and before they buy it, they want to make sure that they will be allowed to continue to use it the way that it is now. They don't want to buy it and then get a summons that says you have to destroy the structure. And
You mean like what I just said?
Exactly. We don't want that to happen. So that's what we're.
Okay, good. Thank you.
Your witness.
Ms. Gregory, could you explain to the board the research that you conducted, especially regarding the maps and the Sandmore maps? I think that's the most.
Yes. So, in my report, that was dated April 2nd, which was previously submitted to the board. What I did is I analyzed what, the current zoning is of the property. Obviously a description of the property, where it's located. It happens to be in the middle of a single family residential block, which is a little bit odd in and of itself, instead of being something like a corner, but, with that said, over the years, it's never been rezoned, but probably for good reason. In terms of if you look at, the entire town, because it happens to be right in the block residential zone. But, we were trying to determine if it did predate zoning. And so when you look on page 3, my exhaustive list isn't that exhaustive because unfortunately, The Borough of Garwood doesn't have a lot of historical records. And I tried also with the County of Union. I was lucky enough that I happen to know the planner over there, and he kind of helped me out to try to obtain any historical information that he could. And so what we ended up with was an old land use ordinance. I only know this from the way that it's typed and photocopied, which is listed as chapter 22, but it doesn't have a date in it, so I'm not sure when that is. The reexamination from 1982, which really doesn't say much of anything. The current land use ordinance, which is dated April, I'm sorry. Actually, I don't even know if it's the current one, dated April 2003. And also a master plan from 2009. The most recent master plan, which is the 2023 reexamination. And then I did get some tax maps. I have a 1906 tax map, excuse me, a 1936 and a 2000. And so what I did identify in this document is that when you look at the 1906 tax maps, speaking too quickly, you see that essentially all the blocks have these 20 foot lots, not 25, 20 foot lots, excuse me. And when you look at, and you'll see that also on pages 4 and 5, and I've highlighted that with a circle on the upper right hand corner of the map. But then when you go to the 1936 map, which is on page 6, there is an assimilation of properties. And what's interesting is that for unknown reasons, there is actually a little bit of irregularity in the rear. Somehow they acquired slightly more of the properties that are located on the next street. I'm not sure why that would have happened, but this map is from 1936. So it's pretty evident that at least this lot was created either in 1936 or prior to 1936. And obviously it's much larger than the others. And then on page 7, we have the 2018 tax map, which essentially is reflective of the 1936 tax map. And one of the differences is you'll see that some of the lots have gotten larger in size because people had bought up these small 20-foot lots to create a larger lot for their single family homes. But it doesn't seem like it prohibited development, the fact that the multifamily is in the middle of this block, particularly with regard to, it looks like it was probably one of the first properties that was subdivided. So we also had the opportunity to look at the tax records, and it does appear that this building was built in 1940 or slightly prior to 1940. So as our attorney indicated, it's pretty old. So, and just by the nature of the architecture, you know, the brick garden apartment style, that has not been built probably since the 50s. So I think that just by the architecture style alone, we can tell approximately when it was built. So we know that it's old. So, you know, we really did try to find out when zoning was first adopted here and find that ordinance, but unfortunately we could not. But I was hoping that, you know, the board would take into consideration looking at the tax maps, because somehow that lot was amassed back at least by 1936. And that structure was obviously built, and as our attorney also indicated, it's still there today. So there was no summons to knock it down. I don't think you could have built something that large without anyone knowing that works in town. Garwood's not that large community, and I'm pretty sure you probably are very familiar with every block that's in this town. So, so with that said, you know, that's what I offer as my testimony, reflective first in the report. And, you know, we're happy to discuss any more questions if you have.
Thank you. Thank
Assume
you.
for purposes of discussion that it was in fact built in or around 1940. How does that compare with the zoning of that parcel?
Well, I'm not sure what you.
When was the zoning in place that governs that parcel?
Oh, you mean, like, I didn't analyze like if it changed but the problem is we don't know when it was zoned for a single family. Okay. We just.
Garwood cannot produce any records to evidence.
That was I was just going to get the answer on the record.
Yeah,
I made several requests, both to Garwood and also to Unica.
And I called the borough attorney because I was completely befuddled by that, and I represent 5 boards in borough. I still, and I offered to come down to Borough Hall and go into the basement with good files.
We don't have a basement.
But I also represented towns that have lost records to flood, to fire, so it happens, and I think that's what happened.
Okay, thank you. Anybody else from the board have questions?
No.
Yeah, Bill.
You used the perfect word, Mr. Attorney, befuddled, because, I know it's been alleged that I'm not sold on this application, and I don't know where that came from, but I'm befuddled simply because there are no records. My gut is, first of all, I think everybody up here has the 1922 zoning ordinance, zoning map. So I didn't see it in your information, but the other applicant tonight produced the 1922 zoning map, and it's zoned single family. Which just, I don't understand. None of this makes sense to me at all. So all that I'm interested in, okay, is making sure, since you represent a prospective purchaser, that when this board says things can remain, doesn't mean that the applicant can't improve some things that are out there, over the course of time. And my question to you is, if you could please advise your client, okay, that if the dumpster area, isn't 100% the way it should be, doesn't mean that just because it exists that way today, that they can't improve it, okay, and that they need to keep that up. The parking lot striping, okay, does fade away. And just because it's, the way it is today, oh, well, that's the way the board approved it. Please, I beseech you to advise your client to keep that property current. The Shade Tree Commission planted about 8 trees in front of the property last year. Appreciate if they, watered them, took care of them. So, I think that between 1906, 1936, whenever this was built, 1940, Borough of Garwood didn't have licensed professionals to review a project of this size. So it would have been reviewed by the county. And county records usually pretty good. But I find it amazing that there is no building permit, no electrical, no plumbing, and that's what I meant by nothing, It just baffles my mind. And that's why I'm very happy, as the mayor indicated, that we're now looking at a use variance. Certificate of nonconformity, yes, does grant some rights, certainly not as much as a use variance would grant. So very happy going with a certificate of nonconformity. If you could please let your client know about the improvements, we'd appreciate it.
Yeah, I can certainly assure you, I've had that conversation already, and they have told me that they are planning to clean up the site and make improvements, not change the building, bedroom count or
Maintenance kind of improvements,
Yeah.
not structural.
Yeah, they're gonna clean it up. They're gonna rehab the units as they become vacant over time and bring them up to modern standards.
Appreciate that. I wasn't going to get into the inside since we're not supposed to, but I appreciate that you did. Thank you.
I don't have anything for, if you want to open the witness to the public, Mr. Chair.
Thank you. With that, yeah, I'm just basically open it up, and I'll ask for a request for a certificate of nonconformity.
No,
Public.
Oh, the public.
Public.
I'm sorry. I'll open it up to the general public for any questions of this applicant. Yes.
Hi, I've never done this at one of these. Jill Paul, I live at 54 3rd Avenue, which is Stephanie Gardens. I've been a resident of Stephanie Gardens for over 12 years, first in a 1-bedroom and then in a 2-bedroom for 8 years. I think I sort of speak on behalf of the entire building. Many of us have lived there for that amount or longer. We've built a community there on 3rd Avenue and in Garwood. We just want a safe, secure place to live with honest owners who truly want the building to be a nice place for tenants and an asset to the community. Knowing they came before the board regarding rezoning is honestly a little troubling, and it makes me question the intent of the new buyers. And I'm really glad that that didn't go through, as is or are the rest of the tenants. Sorry. And we hope it never goes through. Parking on our street is already a huge issue between homeowners and tenants who do not rent a garage or parking space in the back. And hopefully the new owners will keep our building the same. And, I love to hear, okay, yeah, the repairs, because The owners we currently have haven't cared about repairs for years. They just patch things up with like duct tape and stuff. So thank you, Bill, for recognizing that. But to really keep it the same 36 unit garden apartment with the 32 one bedrooms and the 4 2-bedroom apartments, keep our rent where it is, raise it reasonably each year and just be good, honest owners who truly care about the tenants, who care about our building and our small town. This is our home. Thank you.
Ma'am, excuse me, ma'am. You gave a lot of testimony there. Could you just raise your right hand so I can swear you into it?
Oh, left, right.
Because it wasn't really a question, it was like testimony, okay?
Okay.
Please state your name and spell it for the secretary, please.
Jill Paul, Pall,
Okay, and your address?
54 3rd Avenue.
Okay, and do you solemnly swear or affirm that all the testimony that you just gave was the truth, the whole truth, and nothing but the truth?
Yes, and you can knock on all of the doors and everybody will tell you they agree.
Thank you. Michael.
Mike Vina, 210 New Street, Garwood.
You got
Happy birthday, Bill.
You got
Thank you,
quite
Mike,
under
very much.
testify, Mike.
Thank you very
I'm
much.
just gonna say something.
Thank you.
I have no problem with this application. The only problem, and I agree 100% with counsel, what he said about it. The only problem I have with this application is what counsel said about improving the property. This is not the forum for improving the property. This is a certificate of non-conformity. So that shouldn't even come into play. And land use, if there's a problem and they want to conform it or they want to improve it, it's got to come back to the planning board. So I don't think that was proper of even asking that question, and it should be stricken from the record. Thank you.
Thank you, Michael. Anyone else from the general public wish to speak? Seeing none, I'll close that portion of the meeting. At this time,
You have
I'd like-
no more witnesses, right?
I have no more witness.
at this time, I'd like to open it up for a vote on the request for a certificate of nonconformity for this 36 unit garden apartment.
I'll make a motion to accept the certificate of
Second,
non-conformity.
and who had the second?
Stephanie.
Okay. Roll call, please.
Mayor Blumenstock.
Aye.
Ms. Lysack.
Aye.
Councilman Carney.
Aye.
Ms. Bellagio.
Aye.
Mr. Neersted.
Aye.
Ms. Hay.
Aye.
Ms. Bianco.
Aye.
And Chair Green.
Aye.
Motion carries.
Thank you.
Thank you.
Have a nice day.
Council, is your closing imminent?
I'm not exactly sure when they're closing because I'm not the transactional attorney, but I think it's sometimes 60 to 90 days.
Okay, all
I know
right.
the seller is hot to sell it, but I think they've been cleaning up some oil tanks or something.
I'm just
like that.
talking about the resolution. It's not going to be in the next
No,
30 days.
Yeah, yes.
Okay.
Okay, at this time, I'll open it up for the next applicant, and that's case PB 25-05. That's 59 Willow Avenue, and that's an application for a request for a certificate of nonconformity for a two-family dwelling in the RE zone.
I had to show them my zoning map from 1922. Okay, Natasha Montalvo.
Maybe you can adjust it, yeah, for you. Thank you.
Natasha Montalvo with Jabberbaum Worgaff on behalf of the applicant Elizabeth A. Carew on behalf of 59 Willow LLC. No, sorry, it's a mouthful. As you stated, Chairman, that we're here seeking a certificate of nonconformity for a two-family residence. In the application packet we submitted, I submitted the zoning map from 1922 showing that the property was zoned for a two-family. And the house was built in 1957. The applicant's family actually built the house from the very beginning. It was built in 1957, and at that time, it was still designated as a two-family in the two-family zone. I mean, it was a single-family residence, but it was a two-family zone. In 1962, the owners went and got a building permit to convert the house from a single family to a two family. And then in sometime between 1962 and 1974, the property was rezoned to a single-family residential zone. And that is pursuant to the zoning map from 1974 that was submitted with this application. This applicant her family has been occupying that space, that house, as a two-family residence since 1962, when it was converted to a two-family home. And that's my opening testimony. I do have the applicant here to go and describe who was in what unit from the conversion in 1962 to where we are today.
So the key document, counsel, would be the building permit receipt of October 17, 1962,
Correct.
reflecting the conversion to two-family, correct?
Correct.
The only reason I'm focused on that is I did have a conversation with Mr. Hale yesterday about this.
Yes.
So that's really your key document, right?
Correct.
All right.
It was legally converted with with building permits from the town.
All right.
If
So I
we're,
can call your witness.
yes, okay.
Good evening.
Good evening. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And please state your name and spell it for the record.
Elizabeth Carew, Carew.
I figured it had to be Carew just from Rod Carew. I figured that had to be the pronunciation.
No relation, but yes, same.
Your witness, counsel.
Thank you. So can you explain how the house was built and how it's been in your family since it's been built?
My grandparents, Henry and Lilia McClenny, built the house in 1957 as a single-family home. They lived there with my mother and my aunt. In 1962, they converted it to a two-family home, as evidenced in the permit that was provided. At that time, my grandparents and my aunt lived on the first floor, and my parents with my toddler sister moved into the second floor. In 1965, my grandfather died, and they swapped apartments. So my grandmother moved upstairs with my aunt, my parents moved downstairs.
Now, you were born in what year?
1971. So my brother was born in 69, I was born in 71, and we remained in that configuration until 2000.
So from your own personal knowledge, you're able to confirm that from 1969 forward, there were always two families used, two apartments used as two separate families, correct?
From 71 forward.
From 71 forward. Well, you probably don't really remember what happened when you were one, but
Yeah.
But from at least at some point around that time, you know it from your own personal knowledge, correct?
Correct.
And you're testifying essentially that the family's knowledge and consistent what was going on in your family is that since 1962, there were always different residences or different apartments being used, correct?
That is correct.
Continue with, in your timeline.
Sure.
Maybe.
That remained the same until 2000 when my grandmother passed away. My aunt had already passed away. At that time, it was my parents on the first floor and my divorced sister moved home into the second floor apartment with her two toddler children. And again, it remained that way until 2017 when both parents passed away. And so at that time, my brother remained on the first floor and my sister and her children were on the second floors, two separate units. In 2021, my sister passed away. So then it was my brother on the first floor and her children on the second floor. They moved out. We decided to rent it externally for the first time in 2021. And so it was owner occupied on the first floor and an external tenant on the second floor. And it's remained that way until today. In 2022, we formed an LLC because of the rental unit. And so that's history of the house.
Thank you. I have no further questions. 5 minutes.
Okay, at this point in time, I'll open it up for questions from the board of this witness.
Is it separately metered? I see that there's 2 electric meters, but are there 2 furnaces and 2 hot water heaters?
There are 2 electric meters, but 1 furnace, 1 water.
Okay, so it's shared for the whole house. Okay.
And I just have one. Is there any time, within that period of time that it was erected as a two-family, that someone was not living in the apartment for in excess of 2 years? No. Okay. Thank you.
And was this most recent, you said this most recent rental is the first time it was rented, quote unquote, outside the family? But the family members have always been two distinct, separate households.
There's a separate entrance for both apartments. You know, I mean, my grandparents living upstairs, you could knock on the door, you waited for somebody to come in, wasn't as bolted, but there was locks on the doors and it was.
We always have the ashes when we're talking about households. So two separate kitchens, all separate bathrooms, separate, bedrooms, no, no side doors going from one to the other.
There's two bedrooms, a bathroom and a kitchen on each.
Okay. Thank you very much.
Anyone else of the board?
Yes,
Go ahead,
I
Marian.
was just curious why now you're coming before the board for the certificate of nonconformity. So I understand you formed an LLC. Is this a recent form of the LLC, or is this something where you're just like in the process of looking to sell?
LLC in, I'm sorry,
No, it's fine.
in 2022, after we initially rented
Okay.
the apartment late in 2021. And so just considering selling the property now, and the realtor recommended that we
Okay.
get the certificate of nonconformity.
Okay.
just To ease the mind of any buyer.
Thank you. I was just curious why at this point. It's an interesting family history of the evolution of the living in that address. So
Anyone else of the board? Questions? Okay.
Thank you for your time.
At this time, I'll open up to the general public for questions of this witness. Or comments. Seeing none, I'll close that portion of the meeting. Okay, do I hear a motion to accept the,
Just, I don't know if there were comments or discussion from the board.
Sure.
As Don said, I mean, the key document here is the building permit, October 17th, 1962. It's issued by a borough official. It says convert two-family from one family. I don't think there's much more to this application than that.
It's about the most clear piece
yeah.
of evidence we've ever had
Yeah.
on these non-conformity cases.
And the rest of the board is asked about the continuous use. And Mr. Chairman, I think this is a, easy approval.
Thank you, Bill.
Welcome.
Anyone else on the board? In that case, Bill, would you like to make that motion?
I'd be happy to. It sounds like people are surprised I'm voting yes on something. See, she has the documents. That's the difference. That's the difference. I'll make that motion to the town advise the zoning official, I guess it is, to issue a certificate of nonconformity for this application.
Because this is a momentous occasion, I will second Mr. Neerstadt.
Thank you very much. Adele, roll call, please.
Mayor Blumenstock.
Aye.
Ms. Lysack.
Aye.
Councilman Carney.
Aye.
Ms. Bellagio.
Aye.
Mr. Neersted.
Aye.
Ms. Hay.
Aye.
Ms. Bianco.
Aye.
And Chair Greet.
Aye.
Motion
Thank you.
carries.
Thank you.
Thank you.
Congratulations.
Is nobody voting yes? I agree. I've been fighting that battle for a dozen years, Mayor,
I always said aye.
and nobody listens to me.
Okay, we have some new business, and that's Garwood Chicken LLC. And that's for 10 South Avenue, case PB 23-01.
That's you too?
And it's a preliminary and final site plan approval. Is August 23rd, 2023 resolution, and they're requesting an extension of the approval.
I know you're why is that guy standing in front of me?
I'm figuring you talked to Mr. Wine.
So I'm friends with everybody in that law firm, and Aileen Brennan from that office saw me on the Zoom and sent me a text message when I walked out the door and said, Jason Tuvell told me that this was on Zoom tonight, but I can't get into the Zoom link. Can you help me? So I said, I'm going to come back in and try and help you. So she said it's just a letter.
Have you got the letter?
I have not gotten the letter. So if it's okay with all you, I'll step it up. This is quite simple, as you well know, so I won't believe it. It's just a simple request for extension of approval you've already.
Well argued, counsel.
See how we should have the documents, right? Do you have any timeline that they're proposing or not?
I
You don't know?
I have no
Okay,
idea.
all right. Okay.
Yes, they're requesting a 1-year extension.
1 year, okay, thank you.
But not to exceed 3 years, 3 extensions.
I think that's what the statute. provides.
Yeah.
Okay,
Okay.
That's what the statute provides, but the request is for a 1-year extension.
okay, that's what I was looking for. Okay, with that, do I hear a motion to, this request for a 1 year extension?
I'll make that motion.
Second.
Okay, roll call, please, Adele.
Mayor Blumenstock,
Aye.
Ms. Lysack,
Aye.
Councilman Carney,
Aye.
Ms. Bellagio,
Aye.
Mr. Niersted,
Aye.
Ms. Hay,
Aye.
Ms. Bianco,
Aye.
and Chair Green. Motion carries.
That was much. I took one night.
Clients know we're eager.
On that one.
I do enough favor for these guys that.
Bill for at least 2 hours.
Minimum.
And tell
Okay,
them, be up and build that Popeyes.
Adele?
Yes, we do.
We do. Oh, yes, we do.
It was emailed.
Okay, we have, yeah, we will. We have one bill for $2,000, and that's from Parada, Fraser and Forrester, and that's for attendance May 28th and July 23rd. So with that, do I hear a motion to accept that?
Motion.
Those in favor?
Aye.
Opposed? Hearing none, motion carries. Thank you very much. Okay, and Kathy Bellagio, you have something you would like to bring up with the sign ordinance?
Several months ago, we were tasked, Marianne and I, we were taxed, whatever, to look at our sign ordinance and make some changes to it. We met with a representative from the Small Business Association, and they were looking to put flags up, like advertisement flags, feather flags. So Mary and I, when we met with them, we felt that would be okay. But then after the meeting, we spoke with the board, had a meeting. I think it was in, I don't know, April or May. And they said, okay, so what's in front of you now is a proposal for an ordinance that was sent to each of you a couple weeks ago. We did make some changes, some definition changes or updates to the definitions. Since it was very small, our definitions, it wasn't very detailed, it wasn't very much. The feathered flags is a new 106 147. I couldn't fit it in like anywhere else, so we thought it would just be better just to have a section a section by itself. Since businesses like our multiple zones. Like you have the mixed use zone, which is across, which is on North Avenue. Light industrial zone, which is Vermella, technically, even though it's redevelopment. Like it's sitting in a light industrial zone. Then we have the central business district and the general business district, and the CC zone. So what we did is we made it so that they can have these flags if they so choose. A couple months ago, when we presented this in May, we set forth of what we thought like everybody would like, and everybody on the board said that was fine. So here it is. Does anybody have any questions? Oh, and we also made a change because Borough Council was going to have like an amendment with the sign ordinance. So they figured that they wait on their change and just have one ordinance to satisfy both. Jen, would you want to just?
Yes, I'll just,
I'm sorry.
that's okay. We had just been talking with zoning about the political signs. That's usually a question that comes up every year about the size, because while it is in the code, it's done in a very general way and it's a little vague. And we just wanted to make sure that way there was never any question about how big political signs can be, that we would be very specific about it and put it right into that piece of code. So it's limited to a max size of 4 square feet, which is what it has been. So it's not changing. And that's what our zoning officer has been using. But this way, there's no question about it. You don't have to look back at a different portion of the code. So
And-
that's it on that piece.
Just to highlight a couple other things too, as Kathy said, we were going through the sign ordinance and it was very dated. So we did update the terminology and so forth, but also found some things that we pulled back on, like there was within the prior ordinance, it was allowing facade signs of 20 feet in height or 2 stories, which we don't really have, buildings to support that. So we scaled that back. And also with the flag signs too, we have limitations on when they can be displayed, how they're secured, and the duration of time for the new businesses. So it's not something where you can just have these flag signs out 24/7 and for a year. So, and we also looked at how the signage in town is illuminated too, and added some more clarity with that as well.
And the other item was the message signs that we're allowing, the message signs that change, and not scrolling message signs, but changing message signs. Like on the parkway, like you're driving on the parkway, you see those signs, those big signs. They just change like every so often. They don't scroll, they just change. So we are going to allow those.
Yeah, so that's similar to even the police have the speed limit sign with the flashers on it.
Correct.
It doesn't scroll, it doesn't blink at you, but it will change every 10, 15 seconds from displaying your speed. I think the Christmas message was last year, you'll be on the naughty list if you don't slow down. So that type of signage is very common in a lot of the towns around us. And I know of at least 2 business owners who approached through the small business board to me on just, again, the code wasn't really very clear on it. And it became a question of maybe the zoning enforcement interpretation and such. So I really do appreciate the work that
Yeah.
the subcommittee put in here to clarify so many of these things. So when I'm interacting with the business owners, I can give them a clear answer.
Yeah, oh, and the other thing was, and we brought it up in, I think it's May, but my months are.
I think it was, we talked about this two meetings ago, and one meeting got canceled. So
Okay.
it was either April
Yeah,
or May.
whatever. But you're right. With the flag signs, that they should be, that they have, that if some businesses, like if they want to put put the flag sign, on the right of way, they need to check with Borough Hall. I mean, they need to check with the borough because there might be some insurance requirements that the borough may or may not have. So, it's okay, like in the ordinance, but it specifically says, like in this proposed ordinance, that they have to, that they may have like insurance requirements if the borough so chooses.
Kathy?
That isn't something that this board can do.
So, when they request that permission from the borough, do you foresee that as just being a letter and then they would take that
No,
letter?
there's a zoning form that they have to fill out, a zoning permit.
Okay.
And then, like, if it's within the right of way, then that gets, that's something that has to be talked out.
The zoning officer would probably have to confer with the borough administrator.
Correct.
Yeah, that's an existing process with
Yeah,
the zoning
that's an
application.
existing process that but we wanted to put something in there that that the town's protected also.
Yeah.
If they're, we have something in the ordinance, if the winds are so high, okay, well, like over
20.
over 20 miles an hour, they have to take in the flags. Okay, is that difficult to like enforce? But the cops know if it's going to be over 20 miles an hour, that's just a matter of public safety.
Yeah.
Okay.
I think I want to thank you. I think it's very well done. The sign ordinance needed a lot of updating. There were signs that aren't in existence anymore, things like that, terminology we don't use. And I just think we brought it back up to speed with what our businesses need for their current survival, which is always an important thing. We want our businesses to thrive. And I think this is very much, will be very helpful for them. So thank you.
Yeah, and I'll jump in on that too, because they spent a lot of time. I know they did, because I spoke.
It was good.
Yeah, you spent a lot of time and effort on developing this and getting it together and then formalizing it and putting it into an ordinance format and submitting it. So, yeah, I want to thank you for that very much.
But, there's going to be other sections of the sign ordinance that we did not delve into with business, with the, like the other sections that we didn't even go into. Because, what I'd like to do is if we can have Harbor Consultants give us a quote, not on this part of the ordinance, on the factories, like on the CC zones, if those need to be updated. So, Adele, could you,
Go ahead.
who you chair, if we can ask Victor for a quote, we don't know, if he can delve into the parts of the sign ordinance that we did not go into. And also, while you're at it, it was mentioned that we should have something with food trucks, some type of ordinance that that rules the food trucks. If he can get us a proposal on an ordinance for that.
Yeah, I'll be speaking with Victor too, so.
Yes, in terms of the food trucks, I've been looking into it with our borough administrator, just in a general sense. It's there aren't a lot of towns out there with a specific code on food trucks. It is something I would like to see in Garwood as more and more are coming out. We want to support them and, it's great local businesses, but at the same time, we need consistency. Because right now it's essentially, our zoning officer, is deciding things and it puts a real burden on the zoning officer to make sure he's consistent with everything. It would be a lot simpler to have something already set in our code for him to enforce.
And I think the health committee would wind up getting involved with that as well.
So, I'm happy to ask, join support in asking Harbor to, give us a quote for it. Obviously, we have to look budgetary.
Yeah.
That's my hat goes on. But if we can to do something like that, that would be appreciated.
Okay, well, again, thank you.
You open it up for questions, Mr. Chairman?
Yeah, sure. Okay.
First of all, Kathy and
Marianne.
Marianne, I always want to call you by another name and you know that. And I always say it's not the right name. What's her name? And this hasn't been touched in at least 35 years. So very glad to see it being updated. Very, very glad. And I know what it's like to put time into this. Signs are the worst part of an ordinance. So I greatly appreciate that. Second, just very quickly, food trucks. Food trucks was the last ordinance I wrote and got through Plainfield. So you might want to check that. It was very surprising. Food trucks, I did not know. Fire departments involved, police departments involved, health departments involved. I did not know all these inspections. It's very complicated. So I know a good one if you want to look at it. Beyond that, okay, are you looking for action by the board tonight? You are. All right, well then a few questions. Okay, section, I guess well, first off, in terms of location, I know location is tough. Why, since this is a sign, why don't you want to just put it with the signs and put it A or B rather than having it out at 147? What's in between 146 and 148? I mean, why don't we just go with 139A? So that all the sign stuff is located together.
I just thought it would be easier.
It's up to the board.
47,
Yeah. I mean,
just by itself, because there was so much to it, it wasn't a, and I thought about that A.
Yeah, I would.
Because it entails most of the zones. It entails, the central business district, general business, light industrial zone, mixed use zone, and CC zone.
Well,
and having it by itself, it was
I agree.
like much easier.
and I understand what you're saying, but present sign code relates to all zones too. I just kind of think it's a good idea to put signs in one spot.
It doesn't actually though. Like if you look at 10641, it's the following signs are permitted only in these central business.
Right.
Like it doesn't have every zone.
No, but this sign ordinance addresses every zone. If it's not, they're not permitted in residential, et cetera, et cetera. I mean, it just.
General provisions are in 144, which is in the middle of this anyway. I mean, I've putting.
So what's 145?
Putting my councilman hat on, I've for years advocated for having the entire code reviewed and revised because of things like this where stuff was probably inserted at one time or another over the years and they just used whatever number was available next. Not every chapter of the code is really a good flow.
No, but the entire land use ordinance was written in one fell swoop. And so that all goes together. It has nothing to do with any of the other ordinances of the borough unless it relates to or refers to another section of the municipal ordinance. So, hey, it's not my call. I don't understand the rationale. to me, a sign is a sign, and calling, well, what we're gonna call out different lighting regulations in different places in the lighting ordinance, or?
But Bill, the feathered signs are
Mhm.
really more of a temporary sign, so it really is kind of in its own.
There are regulations within the current sign ordinance.
For
as
like,
to
yes, for
hand
like
delivered
A-frame
sign.
signs and so forth, but this just brought on so many different unique
Right.
characteristics, and it was a limited time
I'd like to
constraint.
make a recommendation to the board. Go ahead.
So that was just part of the thought process.
My recommendation would be that these two folks spent a lot of time and effort in developing this. And we're talking about the location and in particular itemized area. And I think they probably took that into consideration, as Kathy had already made reference to. So in my opinion, I think it should rest with what they had recommended in that category in particular. If there are other areas that should be addressed, I think we should move on to those other areas. But I would be settled in the fact that they both reviewed this, they both felt it was comfortable, and it was done in a judicious manner. So I say, let it go.
Mr. Chairman, 106, 147E. Okay, letter number 5. I'm sorry, do I have the right one? No, letter number 4. As the mayor and council know, one of the issues with the current municipal ordinance in general is that it doesn't state who's to enforce certain things. And if you look at letter E4, am I get the right one?
Yes.
Yes, okay. Permission must be given by the borough. Too vague. My recommendation is that I don't know who mayor and council wants to enforce this. Zoning officer's not going to come out at, whatever time of day he's not working here, he or she is part-time anyway. I really think that within any additional ordinances, and I know I've discussed this with the mayor, any additional ordinances that the borough adopts, we should put in here specifically who is to enforce this. I know from other regulations that certain organizations within the municipality don't like to enforce particular regulations. And I really think that this board, we should state, and I'm just putting this out there, if it's the health officer or the zoning officer or the police, who's here on Saturday and Sunday? Who's going to enforce this?
On the next page, yeah. The zoning officer may direct that any.
Saturday or Sunday, who's going to enforce this?
Also
And
says
then
chief
the
of
next line
police.
says the chief of police may direct that any sign which in discretion of the chief of police creates a safety hazard or causes
That's a safety hazard, not a zoning.
slight obstruction to pedestrians or vehicle traffic be removed, modified, or relocated.
That's a lot, but that's not a zoning violation.
Bill, who is it you want to enforce this?
The only entity that we have in the borough that's on 24/7 is the police. And I'm
That the
gonna,
entity that you're proposing.
that's the entity I'm proposing, because nobody's here Saturday or Sunday to enforce it, which means it won't get enforced.
I'm gonna dial that back only because I don't see why there would be a need for emergent enforcement.
And I agree with
Of
that.
the area you're discussing about the setback. I don't see that would be emergent enforcement, and hear me out. If it says permission must be given by the borough, the council designates the borough administrator to operate the day-to-day functions of this borough. The borough administrator could either do it himself or designate any officer or employee of the borough to do whatever needs to be done. So I don't think we need to specify that the police are doing ABC or the zoning officer is doing DEF. It's already specified under areas where there could be concerns, safety hazards, et cetera. This section that you're referring to appears to me to just set out that if you don't have a setback and you're going to use our right of way, you have to use the existing zoning process. That's going to go into the borough office anyway. That's all under the purview of the BA. That's what we're paying for. So I don't think we need to belabor that or amend this just for that. It's clear to me what's meant by saying permission must be given by the borough. That's the borough administrator if we don't specify it any further.
With all due respect, that's going to come back and kick us at some point in court when the judge says who enforces it or who's the borough.
So with all due respect, I would ask council, well, the administrator's not here Saturday, Sunday either.
But this is not a.
No, but this is not the location. Yes, that's.
E4 has nothing to do with enforcement.
Four may not. Okay, but this entire section, okay, these flags, I don't like these flags. I think they're going to be a detriment to the borough. I think they're going to lower our standards tremendously. But regardless of that, they get put out all the time by people who don't have permits. And I just think that, I have taken people to court on such signs, and the attorneys will specifically say, well, where's it say the zoning officer has the ability to enforce it?
That's easy enough.
Good.
Just put in then that it can be enforced by any borough officer or employee. And you don't have to put it on anybody. And then if some attorney who's a wise ass, the municipal court tries to say, no, you can't enforce it, the statute or the ordinance will say it can be enforced by any borough employee or officer.
Beautiful. I think it does make sense for the borough. The other thing, and again, only because I've been there, okay, I think the idea about the wind is terrific. We never thought of that. But again, we need to put in there, okay, who says it's 20 miles an hour? It's like a snowfall. You have to say by the National Weather Service, by Newark Airport, whatever, you have to have an official, or else the person who comes in here is going to say, oh, well, what are you using? So again, just for the borough, okay, it's 20 miles per hour on November 5th, 2025. So the judge can say, yeah, have it, it's over 20. Okay. So recommendation.
So before it just said high winds, so we thought it would be good to put some kind of
Absolutely.
a metric in there, so I don't know who,
I would ask the police, because they've been taken to court when somebody's arguing, parking more than I can say 20 inches, 3 inches of snow. And it's going to be, well, who determined it was 3 inches? And you'll have JFK says it was 2.5 and Newark says it's 2 point, So I would just ask, and whoever the police use to determine 3 inches of snow, same entity for the 20 mile per hour winds.
Okay,
Have we taken note?
that's, okay.
It's noted.
Bill, thank you.
Yeah, that's just because I've been in court with those attorneys, Mr. Frazier, who asked me that. It's like, well, that's the way it went. Doesn't say that. Okay. Other than that, as I said, I don't like these feathered signs. I don't think we should. I gathered that.
All right.
And so I'm not sure how I'm voting yet, but I just wanted to indicate for the record that I wish we weren't doing this.
All
We
right.
heard you the first 3 times.
Can I just want to make sure that I got this, and I will make these changes if in fact it goes through, okay?
I have 2 very tiny technical changes.
Okay,
Under sign announcement on first page, it says occupant to the premises and his activity. I suggested it should be gender neutral. On the
First
first
page.
page, sign announcement says his, I think it should be his/her. And you see,
Yep.
here, Kath.
There it is.
oh, and
Good comment.
his,
Yeah.
her activity and as,
And then below that, about a paragraph below, it's
take it out. Oh,
That's what he's taking. Okay.
an
Advertising.
advertisement, not
Okay.
and the feathered.
Okay.
Thank you,
Look at
Tom.
this one.
I know that Kathy loves to correct my typographic.
Some of this stuff, that's my typing, like in red, and that's me.
I know, but I just
Thank
used
you.
to it.
Anything else?
No, that's it. This, I thought it was very good, actually.
Okay, so on the first page, I'm going to put, his slash her under, sign announcement. Under sign feathered, also known as KN advertisement. I'll make that change. Under under H, 141. 141. H is zoning officer may direct that any signs which in discretion of the zoning officer violates this section or creates a safety hazard be removed, modified, relocated. Additionally, portable signs shall be removed by the owner when forecasted winds exceed 20 miles per hour by the National Weather Service
As determined by the National Weather Service.
as determined. No, no.
At Newark Airport.
Yeah.
Oh,
Newark, at Newark
yeah, I
Airport.
guess the national, that's a little
Newark
broad.
Liberty. Okay,
Newark Liberty International Airport, but I think if we said Newark Airport, that would be defensible in court.
okay,
Okay.
okay.
Kathy, I have one more suggestion. The last page, M, where it talks about high winds for the feather signs, just clarifying that and saying also the 20 miles an hour.
Wait, where is that? N?
So M,
Oh, yeah, that was missed. Yeah.
Oh, the last page?
Yes,
Yeah.
so just.
Yeah, just say 20 miles.
so
Okay,
just
I-
The same.
same thing.
Yeah.
Okay, add the wind verbiage.
Right.
Yeah.
Okay. And then, on that same page, I have an O, of enforcement, a new section O, enforcement shall be by any borough employee, or
Or officer.
officer, period. Okay,
Any other changes? Just educate, our permit shall be valid for a period of 1 year. And I apologize in going through this. When can we put these out? So the duration, signs no more than 2 months. So
if it's a new business, if it's a brand new business, it's under J. Signs for new businesses will be permitted to be displayed no more than 2 months from the date of opening. And then flag advertisement sign is to be permitted no more than 28 days per calendar year from date of zoning.
So why is the permit good for a year? Because the person's gonna say, well, without a permit.
Agree with Bill. That is very,
So it should say 2 months.
I would just lose that paragraph L2 that says it's for a period of 1 year. Because paragraph J already tells us how long they can be for.
I think I don't want to speak for either one of them, but
The debate,
I remember when we spoke about this in the April or May, I don't remember which meeting. The intention was to limit this to a certain amount of time per year. That's why the permit is for a year. You can only display, it says J2, no more than 28 days per calendar year from the date of the zoning permit. So you pull one permit a year, you get 28 days unless you're a new business, in which case you get the 2 months continuous. I think that's pretty clear, and I think it speaks to Mr. Neerstadt's concern about these flags being everywhere. And I will say other communities have these things out pretty much all the time, and it doesn't detract from their downtowns, but that's a disagreement between.
That's my opinion, but I understand what you're saying, but who's gonna count 28 days?
The
You put it
competitors,
up, well, that might be right, you may be right, but if I have a valid zoning permit, I'm gonna put it out. Oh, this is my 20th day. I just, you and I agree in this one, Don, it's giving the permit for years is opening up 10 months of having this.
there's an easy way to rewrite.
Okay.
First of all, in paragraph J, when it says will be permitted to be displayed no more than 2 months, it should actually say be displayed for no more than 2 months. And in paragraph J2, when it says to be permitted no more than 28 days, it should say for no more than 28 days per calendar year. And then when you get to paragraph L, subparagraph 2, it says a permit shall be for a period of 1 year. What I would say it's something like, the permit shall expire 1 year from the date of issuance.
I mean, that's fine. I really do think that we're gonna have lots of.
But
these
Bill,
kind-
you're-
No, Don, I understand. I'm just saying.
Analysis of this is colored by your fundamental objection to the substance.
If many times I fundamentally disagree with something, but still can work with it, I mean, if you have to, you have to. But I'm just saying to those in terms of enforcement, who's gonna count 28 days? Who's gonna count 2 months? Nobody.
Nobody,
And it's gonna be out there for much more than
until somebody
you're saying.
complains.
Exactly.
Yeah,
And then they're gonna.
just like with anything else.
Okay, so I complain, okay, and the guy says, "Oh, I've only had it out there 20 days."
Well, guess what?
Well,
Then
so
they'll
now
do
I
it
gotta- I
again
gotta
after
sit
8
there
more
and-
days.
Well, I think at that point, our zoning officer would have to open up a case and would probably start monitoring it, and
Exactly.
we would go from there, and yeah, they might get a few more days out of it
Right.
before the zoning officer catches them.
This is just a method to be able to control it.
Parts.
And that's basically.
It's about living in a
I
community.
mean, everybody's walking around all the time, I think. Well, it'll be obvious if somebody's
I
putting
think-
their
yeah, I
flag
think-
out, every day too.
We're trying to help the businesses too,
Yeah.
Yeah,
Like being in charge of it.
The other thing too, we did to help the businesses too, is that the ordinance previously said all signage had to be internally illuminated. So we opened it up so that it could be externally illuminated but it had to be controlled, so it was just focused on the signage. Because I think there's something that gives a little more charm to the town and more opportunities for the business owners if the signs can be externally illuminated. So I
And
thought that was a good option for
I
them.
think the original code was written, that wasn't a thing. The internal illumination was probably the only way it could be done. Whenever this was put together in the 70s. So, yeah, I understood your intent with that. And, yeah, I think if somebody's going to push their luck, they're probably going to get a couple extra days out of it, and they're going to end up with a summons.
yeah.
And I don't think the business owners that I deal with all the time are not looking to push their luck that way. They're just looking for the ability when they have like a special sale or event or anything else to be able to attract a little more attention. I don't think any of our owners were asking to put these things up year round.
Mhm. All right, so, in keeping with what Don said, under J1, I'm going to add 4, no more than 2 months. And then, and the same thing, J2, 4, no more than 28 days. And then under L permit requirements, number 2, the permit shall expire 1 year from date of issuance. That's it.
Okay. Very good.
And thank you for your input.
Any other commentary here? Or questions or comments, whatever. Okay, with that, why don't we come up with a vote, and it's to accept the sign ordinance, a motion to accept the sign ordinance, changes as introduced. There's a motion is made to for the ordinance for the proposed ordinance to council for review and adoption. Okay,
Correct.
do I have a second?
I'll second. Oh, I'll make that motion.
Are you making?
I guess it became one.
Oh,
Sure.
that's the motion, Bill?
Yeah, that was a motion.
I'll second.
Roll call, Bill. Hotel.
Mayor Blumenstock.
Aye. Oh,
Ms.
wait.
Abstain.
Abstain.
Ms. Lysack,
Aye.
Councilman Carney,
Abstain.
Ms. Velagio,
Aye.
Mr. Neersted,
Aye.
Ms. Hay,
Aye.
Ms. Bianco,
Aye.
and Chair Reed.
Aye. Motion carries again. Thank you very much.
Just want to thank everybody for their input. It was
Yeah.
very tedious.
Yeah, very nice job.
Thank you.
both you and Mary Ann.
Worked very well, going back and forth. Like with her expertise.
We'll give you something else.
Yeah.
No, we go back and forth.
Just sort of volunteer for another project.
I love doing this kind of stuff.
Okay, with that, we're coming to the close of the meeting and I'll open it up to commentary or from the general public. All right, Michael.
When Kathy started talking about the signage, she had mentioned the scrolling sign and Mr. Carney mentioned the flashing sign. I have one request. Can we slow the spacing down between the messages so us senior can read them? We're going by. They fly by so fast. I have to do a double take and sometimes stop at a light to read what's going on. If we could slow the spacing, who's ever doing the software and slow it down a little bit? it'd be-
What the speed limit sign?
That's a scrolling.
The borough sign up.
Sign?
Exactly.
Yeah.
It'll say something.
okay.
And then it
Right now,
goes
the
to the next message and you don't read it.
Yeah.
You
That's the
miss it when you're
advantage.
out of light. So
Okay.
if we could slow it down. a
All right.
little bit, So we can catch up on. it. That's
Okay.
all I'm asking.
Do you mean just the borough sign or any sign
No, the
that's
borough-
just the borough one?
Yeah.
Because there's gonna be others too.
You're going down, it says go 25 or you're going 31,
I'm-
I don't understand that.
No, I don't mean that. I mean, there's a sign in front of a building, okay? And it flashes, different things like the turnpike. Let's say the turnpike, those signs have to be up there. I'm gonna make this number up, but it's 30 seconds, just the borough sign.
Because we have, you're portraying a message. And sometimes we can read it.
Right, but what I'm,
Too fast.
I would agree. But what I'm saying is that this allows other businesses to put up those kinds of signs also. So,
That's.
so what I'm saying is it should be uniform.
They have, they're
Right.
in charge of that.
That's all.
That's what I'm saying. For it's not just a borough sign, it's
Yeah,
all the signs.
absolutely.
But with this signage ordinance, it doesn't permit scrolling, correct?
Permits scrolling, it just permits messaging.
Understand. I'm just, you brought it up,
I know, thank you.
Mr. Carney brought the flashing. So I'm just asking. If
And it makes sense. I agree with you, yeah.
slow the message down,
Well, you have,
the spacing in between messages.
Well,
you have
there-
3 people from the borough here. I'm sure that message is gonna get,
Thank you.
Thank you, Michael. There are some.
Mike,
Those 3 members are, I mean, there are some uniform standards out there in terms of how long, that message stays there before it changes. So if we could, when it gets to council, and again, council, it's very important to put those specifics into that ordinance before you adopt it, because you stand a much better chance of, winning in court. And I'm making this up. If we want that message it's got to stay on there, say 30 seconds, ordinance should state that. So whatever that message is.
I think of the
Okay.
cases you think we're gonna have about this.
I'm talking about the time
Yeah,
between messages. So you can display it's 79 degrees or it's October 31st in Garwood. But when it goes from that message to the other one, slow it down a little. In between, just one's running into the other.
So what,
It may or may not with the software be possible. The software that we have for our borough sign is so old that we really don't have the ability to put anything up, to be honest. So that's a discussion for a whole nother town, but we will.
He's a software expert.
We tried this one too.
this software might be older than even I am.
This turns into a budgetary discussion.
It's
this. That's
Okay, thank you, Michael.
Sluker was on
Yeah.
the board.
Okay, I think we have the idea of what's needed, and we can do whatever we say.
Start over. It's just, I know it was challenging even to get it back up in the first place, displaying like the correct time and stuff. One of the police dispatchers had a extremely old laptop that ran the correct version of Windows that's been discontinued for like 15 years. So we will look into it. I'll have that conversation with the chief next week or tomorrow at council. I just don't want to promise results.
I
Okay,
I forgot to mention, Adele, I'll make these changes and I'll send them to you so you can forward them to Borough Council,
Okay, anything else?
okay, thank you.
if that's okay.
Okay, I'm going to ask the public to address the board.
I'll go last.
Well, I think we are asked, Bruce. Unless there's, I take that back. Is there someone else from the general public who would like to speak? No, okay. In that case, Bruce, you're on.
With the amount of papers.
And just as a note, Bruce, we discussed this a little bit before. We're not going to discuss the specific changes that you had proposed based on whatever this is. I think it was addressed by Harbor Consultants representative directly to you as well. So with that, we'll be happy to hear you and to accept whatever or take whatever handouts you have. But we'll let you go forward.
Put it another way, we're not having a hearing.
Thank you.
All right, but I'd like to explain the possibility of rescinding, as my letter said, rescinding what was agreed to at this point with the affordable housing numbers and possibly recalculating them. That's what I'll be talking about.
Again, you're permitted to address the board. There's not going to be a hearing. Go ahead.
Oh, yeah, okay. I mean, there may be a Q&A though.
I don't, if anybody decides to ask you a question, I guess that could be possible.
Okay. Ladies and gentlemen of the planning board, Bruce Patterson, 325 Willow Avenue. At this point, I did send a letter with a little chart comparing up and down our corridor for towns. In addition, what I'm going to be, I did say I would discuss it further, of course, at the meeting, and I gave Adele a 2-page handout, which I will go into later on.
We're going to the discussion also to, again, let's say
It's typically 5 minutes.
5 minutes. So playing the strategy accordingly.
Obviously.
Bruce, I
Yes.
believe that's a standing rule of the board that when we have this portion of the meeting, that any member of the public can raise an issue to discuss, that they get 5 minutes.
Okay.
You surely don't believe that you're entitled to special treatment, do you?
I take the fifth on that one.
Interesting.
Yeah. But anyway, of course, there could be a part 2 at the next meeting, right? You know, to continue the discussion.
Interesting choice if that's how you're going to use some of your 5 minutes.
Yeah, okay.
Okay, let's start the clock now.
Okay.
Did.
You know, just referring to the chart. I put down the various towns. I even threw in Park Ridge. But anyway, if you really look at the AH numbers, how the decrease came about, basically the other towns had like a 75% decrease, and Garwood only had a 33% decrease. I went to Cranford, I went to Famwood, of course, I went to Garwood, and I asked a lot of questions, and I also read through the housing element plan that was put forth on the towns. Even Westfield I did read, and I just made this chart just showing, you know, the decreases. And oddly enough, each town actually had a separate planner that did all these calculations, and they came out to a 75% decrease. Us, who I mentioned in the letter, arguably we're probably a highly developed town, less vacant land. Our RDP actually came out to be 53 according to the meeting that I went to on 5/28 and the handout that Ms. Stretta had given us. The 53 number, you know, that he put out, the realistic, the RDP, I mean, he mentions it in his housing element plan on page 195 and also page 53 of the 622 pages. The sad part about it, all the plans were searchable, but the Garwoods wasn't. So, I mean, it was really a pain in the butt trying to go back in and dig out the numbers. Just to continue, the reason why I'm here, and this is the explanation that I'm going to give you from this second handout that was given. If you start at the top, I feel that the numbers were misinterpreted because all the towns basically fell onto this exclusion type paragraph, which of the amendment of 2024 housing amended law, page 32 of 50, paragraph so and so and so. It says any municipality that receives an adjustment of its prospective need obligation for the fourth round or subsequent rounds based on lack of vacant land, which is Garwood, shall, as part of the process, adopting and implementing its housing element and fair share plan, identify sufficient parcels likely to redevelop, which it did, during the current round of obligation to address at least 25% of the prospective need obligation that has been adjusted and adopted realistic zoning that allows for such adjusted obligation. In taking 25% of the 80 units that the DCA provided to us, that comes down to about 20 units. So right now, we're looking at 20 units where Mistretta had actually come up with approximately 50. So there, there is basically what we should be doing. And other towns actually did the same thing when I went to their hearings and I asked that question and they all fell back onto this single paragraph here talking about 25%. If we dispute our findings, which would obviously be Attorney Fraser, but anyway, based on a technicality of the misinterpretation.
Excuse me, Mr. Patterson.
Yes, go ahead.
I don't know that it would be me at all. I don't know where you get that idea from.
Okay, I appreciate pointing that out. But we probably can rescind it based on this paragraph that I put on page 10 and 11 of the 50 pages of the law, that we are permitted to dispute. So turning on, turn to the second page. We have bonus credits that we can take. So if we take 25% of the 80, which comes out to 20, we can also take bonus credits from, say, the St. Anne's property of 5 credits, which brings it down to 15 units of affordable housing that we would be obligated. And we can't take more than one type of bonus. Page 35 and 36 of the amended law actually goes on to list other credits that possibly we can address. But at this point, we're looking at only 15 affordable housing units. The amount of documentation, by the way, this very last paragraph, the amount of documentation, I do agree with Ms. Strader that we have to prove our round 3 that we actually achieved what we were shooting for on round 3. However, I am back to the round 4 numbers. And I think we're far off on that we really can not only get down to 20, which is 25% of the 80 units, but we actually can get down further to 15 affordable housing.
Mr. Chairman, I would
units.
note that Mr. Patterson has used his 5 minutes.
Okay, thank you. Can you write it up?
You just did. That was the 5 minutes, Bruce. Thank you.
This is amazing. This is certainly amazing what I get subjected to. But anyway. Can't even have a wrap-up comment? Is that what you're saying?
Mr. Patterson.
Yes.
I agree it's amazing. And you were given more time than the 5 minutes. You routinely take, as is your right as a citizen. You take the opportunity to address this board frequently, and you are treated always with the utmost of courtesy. You were given the utmost of deference, and you, as is your right, use every bit of it. But everybody has rights, and you knew at the outset what the rules were, and you chose to use your time in the manner that you did, and that's fine.
Okay, that is explained, and hopefully if anybody has any questions, they can contact me later on. But those are the paragraphs to take a look at. Okay, thank you very much. Thank you, Bruce.
I would just note for the record, Mr. Chairman, that I know that Mr. Mistretta has provided an analysis of Mr. Patterson's arguments. I believe, for the record, that Mr. Patterson's arguments are completely off base for the reasons set forth in Mr. Mistretta's analysis.
Thank you.
As noted.
Found it wrong, though. Thank you.
Thank you. Okay, anything else of the board that needs discussion? If not, do I hear a motion to adjourn?
I'll make the motion to adjourn.
Second.
All those in favor? Thank you. All right.
Great color on you, Don.
Thank you, Ron.
It's the new jacket. I just forgot about my ward.
I like it.
Got
Yeah.
it, thank you.
This can go.
Well, have a nice month. Yeah, we'll see you in August. Are we gonna meet in August?
Yeah.